Okay, I'm sorry, Ms. Fosberg. Tell me, Judge, how are you?
Very well. I'm here for Francisco Hernandez.
In jail or on bond?
He's on bond.
Oh, he's got a bond violation.
Yes, Judge.
Do you mind having him approach, please?
And Judge, there is a representative from the bonding company here in court.
Welcome back to another explosive day in the courtroom where bonds hang by a thread, parents fight for their kids, and judges lay down the law with no room for excuses. Today, we're diving into bond violations, DWI cases with missing evidence, gun charges that get dismissed due to poor police reports, and a heartbreaking moment where a mother begs a judge to help her son who's facing 2 serious felonies. We got defendants testing positive for drugs and alcohol, immigration consequences looming over heads, reckless driving cases where lives are at stake, and burglary suspects caught red-handed with screwdrivers and gloves. One defendant gets a harsh reality check about the law of parties, where just being present at a crime scene can get you charged with murder. Another learns that a theft conviction will brand him unemployable for life. Buckle up. This is raw, unfiltered courtroom justice where accountability meets compassion, and where one wrong move can change everything. Let's get into it.
Failed to go test when you were ordered to test. I'm sending you now for a drug and alcohol test, and you're to come back. If you ever miss again, it's not going to go well for you. Do you understand? Okay, I'm sending him now for a test. He has to come back. All right. Take a seat, please, sir.
Yes, so Your Honor, I do understand that the drug test did come back positive. I would ask that the court not revoke his bond, or if it does, to set it at a low amount. And the reason for that is, first of all, this is just a first violation. I'd also ask the court to consider that Mr. Hernandez's mother is waiting outside in the hallway with his baby sister. Whatever the bond is, she's going to pay it. So any amount of bond, it's really just going to punish her. So we would just ask.
I don't even know what he tested positive for.
According to pretrial services, it's THC and alcohol, Judge.
Can you tell me about the felony case that he has, please? Because I don't remember what it is.
The felony case is a tampering case, Your Honor. On January 22, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a discharged firearm call in a residence. A resident told the law enforcement officer that she heard shots and then saw a green four-door vehicle speed away. Law enforcement officer found a vehicle that matched the description parked illegally in the same residential area. As the law enforcement officer pulled up behind the car, multiple males exited, and the law enforcement officer activated his light and sirens, and the males began to obey on foot for approximately 100 yards until the law enforcement officer detained them. A resident videoed the defendant tossed weapon in front of the residence and he evaded on foot. The gun was recovered, and the defendant's clothing matched that of the male who tossed the weapon.
So the felony was that he tossed the weapon.
Yes, Your Honor.
And the evading is he just takes off because of this.
Yes, Your Honor.
Can you go grab Mom, please?
Yes, Your Honor.
Let me give her that book. I had that fever, Donner.
Thank you. Look, what do you say?
Right here, the judge highlights the tension between a parent wanting to help and a teenager making bad choices. Courtrooms often see this dynamic, love versus accountability. The defense attorney argues that revoking the bond or setting it high will just punish the mother, who's waiting outside ready to pay whatever it takes to get her son out. But here's the reality. Francisco Hernandez is facing 2 serious felonies. He was involved in a case where gunshots were fired, a vehicle fled the scene, and when police tried to pull him over, multiple males, including him, ran on foot. Then he evades arrest. And now, he's testing positive for THC and alcohol while out on bond. The judge has to balance compassion for a worried mother with the need to hold her son accountable. Notice how the judge frames the consequences without demonizing the family. He's not blaming the mother. He's trying to make the son understand that his actions have ripple effects. This is a powerful life lesson unfolding in real time. Do you think the judge should consider the mother's plea, or should consequences be consequences regardless? Drop your thoughts in the comments.
Your son is charged with 2 serious felonies.
Yes.
And I'm trying to do everything in my power. Trouble. I've ordered him not to use drugs or alcohol, and he's testing positive for drugs or alcohol. How do I get it to stop?
I mean, when he had the monitor, everything was okay. I'm gonna be very honest with you. When he had the monitor, everything was fine. He wasn't going anywhere. And I think that's what kept him on track. But right now, without the
Someone
monitor,
take it off?
as soon as they took it off, it just felt like, I guess, it wasn't a big of a deal to him, probably. I mean, he's still a kid. And I don't, like I told him, it's not that, like, I know you think it's easy or whatever, but it's not. It's really serious what you're going through right now. And I tried to get him to understand that.
My only issue is that I'm gonna put on him now. He knows that he violates and mommy's just gonna bond him out.
Oh, no.
Then he's gonna sit here and, I'm gonna do whatever I want because mommy's gonna bond me out.
I talked to him, I go, this is the first and last time I'm helping you. And I support him with everything, and he knows it, whether he's right or wrong. He's my kid, I'm gonna support him. But if he's wrong, of course, I'm gonna let him know and make him see and understand why he's wrong. I'm not the type of person that's gonna be like, oh no, it's okay, don't worry about it. No, because it's not okay, what he's doing is not okay.
Help me help you. I'm trying to do everything in my power to keep you from getting a 25-year sentence because you're hanging out with the wrong people.
Agree.
When someone shoots a gun, the bullet goes up, it goes down, it ricochets. Let me give you a piece of perspective. If I say, hey, Mr. Hernandez, help me out. I need some money because my mom needs to go on operation. I'm gonna go hit up this bank. And I say, hey, come on. All you gotta do is drive. I'm gonna go.
This is the law of parties in action. Even if you didn't commit the crime directly, being involved or nearby can make you criminally responsible. Young adults often underestimate this, and the judge is about to break it down in the most powerful way possible. He's using a hypothetical scenario to explain how the law of parties works in Texas. Imagine this. Your friend asks you to drive them somewhere. You don't know they're planning to rob a bank. You just think you're helping out. But then they go inside, kill 4 cops, run out with a bag of money, and jump in your car. You drive them away. Who gets charged with capital murder? You do. Even though you didn't pull the trigger, even though you didn't know what was going to happen, the law says you were a party to the crime. That's how serious this is. The judge is warning Francisco that if he's hanging out with people who are shooting guns and a bullet ricochets and kills someone, everyone in that group can be charged. It doesn't matter if you didn't fire the weapon. It doesn't matter if you didn't even know it was going to happen. If you're there, you're liable. Pay attention. This is why your choices and your company truly matter in the eyes of the law. Have you ever heard of the law of parties before? Let me know in the comments.
Get it, and then we're gonna go out. You didn't know this, but I go in there and I kill 4 cops, right? And then I run out to the car. I got a big bag of money. We take off. You drive me out. Who gets charged with capital murder?
Both.
It's called the law of parties. You didn't know that I was going to do that. Had you known, you wouldn't have gone. But if you're hanging out with a bunch of people and they're shooting guns and it ricochets and it kills someone, who gets charged?
Everybody. He knows that.
You are making decisions.
For him.
You are 18 years old and you are not allowed to use. I have made that a condition of your bond. And I'm going to tell you now, the next time you violate any of my condition, I'm going to make your bond so high you're going to have hair falling out. Do you understand? I don't care if Jesus is here with you. The next time you understand?
So,
I'm now going to put a monitor on your ankle so I know that you're consuming alcohol. And I'm also giving you a curfew. If I find that you're out in the middle of the night, I'm going to rip you a new one. Do you understand? This system will not fail you. And I'm going to stay on top of it until you do start doing right. Is he in school? What is he doing?
He's in school and he works. When there's no classes during the week, he works. But on Saturdays, he does work. Every Saturday, he works.
Okay.
They leave the house between 3 a.m. and 4 a.m.
What?
Yeah, because he has to live with his dad. His dad goes there.
Oh, okay, so he's going with that?
Yeah, he goes with dad.
Wonderful.
And he comes back with dad, or I pick him up if he
Okay,
works early.
I want to give him a curfew.
Okay.
I will go with whatever you think is appropriate, okay?
Whatever you want, I'm okay with.
I just don't want him out in the middle of the
Oh, me
night.
neither.
As long as you're working, as long as you're. But if you're clowning with friends, it's not gonna happen. So any of the co-defendants that in this case, no hanging around with, you will get tested 50 days from today. If I find that you're still using,
That's beautiful.
you know what's gonna happen. You know what the expectation is.
Yes.
You now know you have no one to bond you out. So that the next time you make a decision out there that's not a good decision, you will be stuck like Chuck. Do you understand? Okay? I don't like to put people in jail for the sake of putting people in jail. I want to ensure that we're all on the same page. That's why I wanted you here, so I know that you and I are on the same page. As long as you're happy, I'm happy.
Yes.
Whatever you need, all you need to do is let me know, here, you mind give. So if you ever need anything,
so much.
just let us know, and we're there for, if he starts acting a fool, because anything, if he's not telling you, if you tell him to jump and he doesn't say how high, just call me and let me know.
I've never had an issue with that. My issue is always like right now, just him leaving the house and not saying anything. That's my only issue. But other than
You
that,
don't have permission to do that anymore.
he's not a disrespectful kid. He makes bad choices. Like I tell him, you guys are not dumb. Yeah, choose the wrong crowd, make the wrong decisions. But other than that, I mean, I've never had an issue with him, to be honest.
You speak Spanish. You understand Spanish? Dime con quién andas, yo te digo quién eres.
Very true.
That's what life is. Okay, we're good.
We're good.
Okay, thank you, Mom.
Thank you. Come on, baby.
May I be excused?
Yes, sir. I have to wait until pre-trial releases
No,
you.
ma'am. Levantarse y tirarle la basura. No, hermana, got it. Go, chica, go.
Ready? Yes, ma'am. Okay.
Judge, the silence. And so it's my understanding there's no alcohol. He's got a device also already, I think, or at least we can double check.
All right, sir. You are Mr. Cutler.
Kubler, yes, sir.
Kubler. Mr. Kubler, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I see. So he's also charged with abandonment. Is it out of the same transaction?
Yeah, we had a long discussion with him this morning.
I don't know anything about it. Let's find out what's going on, please.
On April 11th, 2025, an officer was dispatched to an unknown accident, and noticed a vehicle, a pickup truck, illegally parked in the front yard of the residence. There were fresh tire skid marks, a broken wheel, and axle visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with the complainant, and then, sorry guys, it said the damage to the Jeep was brought on $5,000. The defendant admitted to driving the truck. Was later identified. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed him exit the vehicle from the driver's side door. Upon exiting the vehicle, the wheel witness observed he was not stumbling. And then the wheel witness observed slurred speech and strong odor of alcohol beverage emitting from the defendant's breath and person. The defendant also admitted that he was trying to clear the scene and go home, but his vehicle was stolen. The officer made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. And the officer then conducted a standardized field sobriety test, where he witnessed. Sorry, Your Honor, the DIMS leaves off and does not show the standardized field sobriety test results. The The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10. The defendant said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
Or, I'm sorry, he did not. He did not. I apologize. Just a moment to see if I can.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. It also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. So I really can't make a lot of sense out of.
It's like the DIMS you're reading these like going through a drive-through, man. I mean, really, who's writing the reports?
Yes, Your Honor.
Over and over and over. I mean, really.
Trying to see if I can find anything else.
Case after case, we're just,
So Judge, things don't say it, don't say what is the results of those van revealed sobriety tests, and we do not have an officer back yet.
how on earth am I supposed to find probable cause when Mickey Mouse is writing these reports?
I don't say, I don't know why it's not in the DIMS. Obviously, we didn't write it in here. We represent what is written in there, and so I understand your frustration. I'm highly frustrated.
Mr. Kubler, I'm gonna find no probable cause in your case. Don't kill anyone. You know, every single day on the news, how many people die in our county because of a DWI? How many? Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out. Now, this is not to say that they may not indict this case at a later time, but be whatever, just don't kill someone, please. Take a seat, please, sir.
Thank you, Judge.
Thanks.
This is where sloppy police work can derail an entire case. The judge is visibly frustrated because the officer's report is so poorly written that there's no way to establish probable cause. Let's break this down. The defendant was involved in a DWI crash. He hit a parked Jeep, causing over $5,000 in damage. A witness saw him stumbling, slurring his speech, and smelling of alcohol. The defendant even admitted he was at a 6 out of 10 on intoxication and said he didn't think it was safe to drive. But here's the problem. The officer didn't perform field sobriety tests. The report doesn't explain whether the witness was credible or reliable. And the blood test results? Not in the file. The judge compares reading this report to going through a drive-through. Fast, sloppy, and incomplete. He even says, how on earth am I supposed to find probable cause when Mickey Mouse is writing these reports? That's a brutal call-out. The defense attorney acknowledges the frustration, but says they can only work with what's written. And because the report is so incomplete, the judge has no choice but to find no probable cause. Mr. Kubler walks free. Not because he's innocent, but because the officer didn't do his job properly. This is a perfect example of how critical documentation is in the criminal justice system. One poorly written report can mean the difference between conviction and dismissal. What do you think? Should officers face consequences for sloppy reports? Let me know below.
Is it Bear?
Bear, yes, sir.
Miss Bear, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Stop. Just don't say anything, please. We're going to do probable cause. I want to know what happened, and then we'll go from there. All right, you ready?
Yes, just one moment, sorry, still there. All right, thank you, Judge. On April 7, 2025, in Harris County, Texas, a law enforcement officer conducted a traffic stop for illegal intent. I will preface to you, Judge, there are no further facts to describe illegal intent. Upon contact with the defendant, the law enforcement officer noticed the strong odor of marijuana from the vehicle. When the law enforcement officer asked for insurance, the defendant opened the glove compartment and law enforcement saw a bottle of methazine in plain view.
Yeah.
The officer then conducted a probable cause search that revealed a handgun in between the center console and the passenger seat where the defendant was sitting. The defendant stated that the gun was hers, and that's all I have.
Were you here? I guess you didn't. We were here Friday, same thing on Friday. We've got tent and nothing else.
I was here Thursday with the illegal tent, but they don't actually, there was nothing reported that they did where they don't grading up when they do traffic stop.
Ms. Abear, I'm going to find that there's no probable cause to go forward with your case. You have an open felony case. It's very possible that if you continue to pick up cases, they revoke that bond, put you in jail, and make your bond sky high. Do you understand? While you're on bond, you're supposed to live as if you have a halo above your head. And when you don't, there are serious consequences. Get a clue. Do you understand? All right, please take a seat.
Judge, I do need to let you know something before we begin. This client had, I can't remember what kind, he was a victim of a violent crime. And he understands what's going on, but you might need to slow down a little bit right now. Thank you.
Okay, what is his last name?
Hernandez, and it's Anthony, Your Honor. He has 2 cases.
Mr. Hernandez.
Buenos días, señor Hernandez.
Buenos días, señor.
Good morning,
Was
sir.
charged with 2 very serious cases. You were charged with driving while intoxicated. You were also charged with tampering with a government record. You just had a tampering dismissed 2 weeks ago, and now you have another one. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. On the tampering case, you're facing up to a year in jail and or a $4,000 fine. On your DWI, you are facing up to 6 months in jail and or a $2,000 fine.
On March 16, 2025, an officer observed a vehicle and ran the tag that observed and which was found to have no return on the traffic stop was initiated. The officer observed the defendant with low roll and missed multiple opportunities to safely pull over. The officer made contact with the defendant and observed the odor of alcoholic beverage in the vehicle. The officer also observed 2 40-ounce glasses of Modelo, both open and a quarter%.
Drinking while driving?
Yes, sir.
The officer requested the defendant exit the vehicle and the defendant was detained. The defendant declined to answer any questions and center as right tests were conducted. The officer observed 6 out of 6 on the HGN, 5 out of 8 on the walk return, and 2 out of 4 on the one-leg stand. The defendant consented to a breath test, and the results of which were 0.135 and 0.133. While at JPC, the defendant admitted that the identification card provided was fictitious. The officer reviewed the identification card, and the identification card had a fictitious date of birth, and his first name was listed as his middle name. The card had no fault. It was also very flimsy, and the lettering was not consistent with normal federal identification.
Mr. Hernandez, I'm going to find that there's sufficient probable cause to go forward with your case. I would hope that you recognize it's damn elementary that you're not to have alcohol in the car while you are driving. You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I will have a contempt of court hearing. You could be facing an additional 6 months in jail and a $500 fine every time you drive. You are not allowed to drive. Do you understand?
Yes, sir.
Is he here on an asylum claim? Does he have status here?
Judge, I'm not sure if asylum is the right word, but he does have an avenue through immigration based on him being the victim of the violent crime.
Not in this country with permission, and you go to jail. What happens?
pasa?
Como dice la pregunta,
What was the question?
por favor.
Please.
¿Qué pasa si tú andas a la cárcel y inmigración te encuentra? ¿Qué pasa?
Va a ser deportada.
That's what you need to think about when you're out there in the free. You're ordered now not to consume alcohol or illegal drugs. And I'm going to put a monitor on you so I know that you're not consuming. This is the promise that you're going to be signing with me, Mr. Hernandez. And I want you to understand, I will do everything in my power to protect my public at all costs. Do you understand me?
¿Lo entiende?
Sí, señor.
Yes, sir.
Sure.
¿Seguro?
Sí, señor.
Yes, sir.
If you were here because you were a victim, or if you were a victim of a violent crime, you have no clue what happens in our jails on a daily basis. There are some parts of the jails that are so bad, officers won't even go. Keep that in mind when you're out there, because if I find that you break any of these bond conditions, I will put you in jail. And if you're unlucky enough, you will get a detainer and you will sit there and you will be stuck like Chuck until these cases are over with. And then you get shipped off to immigration. You get no more warnings from us. Because you have a lawyer, I will waive your appearance, but you're ordered not to consume alcohol or illegal drugs. I'm going to randomly test you. For now, I will have you go to Victoria, sign a reset. After that, you'll get with breach off of your bond conditions. After that, you'll be free to go. Be very careful. No more warnings, Mr. Hernandez. Okay, thanks. For the time being, I'm going to put a SCRAM on him, so I know that he's not using. I'll pay for it so that it doesn't come out of his pocket.
Thank you, Honor.
I did. Yeah, there's one up there. Okay, and then if a while passes and there are no issues, come back and talk to me, but I want to make sure that he's not using.
Thank you, Judge.
Yes, ma'am. Mr. Villasana was a no-show for a drug and alcohol test, so that's why the bond violation was.
Mr. Villasana was a no-show for a drug and alcohol test, and that's why the bond violation was filed. At the very end of this case, the judge sets a SCRAM monitor and outlines a zero-tolerance policy. This is where the stakes hit hard. One more violation, and the consequences escalate dramatically. For those who don't know, a SCRAM monitor is an ankle bracelet that continuously monitors alcohol consumption through sweat. It's used to ensure defendants aren't drinking while out on bond. The judge even says he'll pay for it himself, so it doesn't come out of the defendant's pocket. That's compassion, mixed with strict accountability. But here's the warning. If Mr. Hernandez violates his bond conditions again, he's going to jail. And because he's here on a special immigration status as a victim of a violent crime, if he gets a detainer, he's stuck. He'll sit in jail until his cases are resolved, and then he gets shipped off to immigration. No more warnings. No more second chances. Ask yourself, if this were your friend or a family member, how would you ensure they follow the rules? What would you do to keep them from ending up in this situation? Drop your thoughts below.
Filed. Guys, hey, did we send Mr. Villasana for a drug test on Friday? I can't remember.
Yeah,
Please,
I just a positive for change.
stop. I don't think I ordered him not to use on the theft case, but we ordered him not to use on the new case. Mr. Villasana, you're not to use alcohol or illegal drugs. I'm going to test you like crazy. If I find that you continue to use, I'm going to lock you up. I don't know who you have in this life that's ready to pony up $10,000 plus for you to get out. If you don't, you will be stuck like Chuck in there. Do you understand? The only thing I'm asking you to do is don't pick up a new case and don't use. Do you understand? I'm not asking you to split the atom here.
Yes, Judge, it was positive for THC.
That's it.
Yes.
So I will give you a pass for 50 days from the day that you were ordered not to use, which was March 20th. 50 days from that day, you will be tested again. I hope that you're not using. Do you understand? Okay.
50 days something.
From that day, correct. We'll have him come back and we'll have him test again. Stay in contact with your lawyer. You guys get on the same page so we can figure out what's going on, and then we'll see you soon. Don't use. You understand?
Is there any way we could speed this up or I could just plead or figure?
No. Life is hard enough as it is. When you start just adding on convictions, it's just going to make it all the worse, man.
I don't have time to be coming up here. I already lost my job because I can't drive.
See, guys, do you see if there's something?
But Judge, I already spoke to him.
Chadwick when we stood down.
He said he wanted to send so we can try to get figured out. And come up
Is there
with-
something that we can do? Like,
I can talk to Chadwick.
you guys talk, see, perhaps there's something that we can do to where he works something out where it does it on the outside so he, doesn't come back, but just don't use.
I just want to see if I can get a.
Just be quiet.
Don't, when you put stuff on your record, Mr. Villasana, you become unemployable. When you have a theft, what do you think happens when you get a theft on your record? You're branded a thief forever. Do you think people hire thieves? No. You want to get an apartment? You can't even get an apartment when you have a theft conviction, Mr. Villasana. You think it's bad now. A theft conviction hoses you for the rest of your life, man. When you take a half-ass approach to things, you get a half-ass result. I know that he's working hard to get the best thing for you. Sometimes it takes a little bit of time, but in the long run, it's for your benefit. I promise. Be patient. Let's see what they can work out today. Hang tight.
Keep in mind, we're here today because of the bond violation. Normally your parents is away, you need to come down here.
So just hang tight. We're working. Just
Can I
don't.
get a bus pass?
I'll get your buzz. Just hang tight for me.
So, Your Honor, I have made an offer. It would be a 12-month deferred with T-Raz, rate of UAs, and I wanted to see if you had a high school diploma, if not a GED, as part of that, on the theft, and we don't look at race.
So right now, Judge, he's thinking about it, so we probably want to reset it today. But the issue, I'm approaching on the fact that as a condition of bond, he cannot drive. So he wanted to ask the court to modify his bond condition, allow him to drive so he can go to work, so he can get a job.
I'll run his license. Just so we have a-
Come up, Mr. Villasana.
So, yeah, I don't see a DL number in here. Let's see the state ID shares.
Does he have a driver's license?
You have a driver's license? Yes.
Yeah.
He says he has a driver's license, Judge.
Do you have the number so we can just make sure that he's licensed?
But I have the photo.
Right, what's the number? You know what the number is?
Yeah, I'll get the number
Let
right
me pull up my search bar.
Okay. What are you asking for?
Allow him to drive, Judge. I think the bond condition, he cannot drive because of the reckless driving case. He's saying that in order for him to get to work and get employment, he would need to drive. So you're requesting the court allow him to drive.
The only thing that I want in this life are my streets safe. When you drive maniacally on there, going at speeds of 120, whipping in through traffic, and you're putting so many lives in dangers. You need to understand that it's a privilege. It's not a right. As long as you don't drive in this manner, I'll allow you to drive. I'm going to have you sign bond condition to the effect that you're not to race, drive recklessly, donuts, participate in street takeovers. If I find that you do, the first thing I'm going to do is I'm going to put you in jail and I'm going to make your bond sky high. Do you understand? I will give you a privilege to drive back for you now. But don't drive crazy. Are we on the same page? Okay. So it's not an old case. So now there's no excuse. I'm going to test you again. You've no excuse to miss a test. You understand? You miss again, it's not going to go well. Okay, done.
Okay, go ahead and file those right now.
So we're going to file conditions. Do not leave until you sign them. Once you sign them, you can go. All right.
Now you sit back in the audience, Judge.
Go if you want to go down. Guys, does he go down to the 7th or to get a bus pass? Where does he go?
That's 49. French until.
If you go to 49, they'll give you a bus pass there. Okay? All right. Good luck. Got it. Okay, so just hang tight. They're going to call you up.
You want to sit back over there? Sit back over there.
Mr. Bullock, you're charged with 2 cases. Your hands down, please. You're charged with burglary of a motor vehicle. You're also charged with failure to identify oneself. On the burglary case, you're facing up to a year in jail and/or a $4,000 fine. On the failure to ID, you're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Okay. On April 7, 2025, or I'm sorry, excuse me, on April 7, 2025, in Harris County, Texas, law enforcement officer dispatched for the burglary of a motor vehicle call and received a description of 2 suspects by the complaining witness. The complaining witness advised that the 2 suspects attempted to steal a vehicle by breaking the ignition cover. A neighbor was leaving for work, and the suspects left when they heard the voice from the neighbor leaving. A screwdriver was left on the vehicle floorboard, and the complaining witness's Ring doorbell captured the incident. After a brief search, 2 individuals, including the defendant, were found that matched the complaining witness's description of the suspects. The defendant had screwdrivers and gloves in his backpack, and the complaining was able to positively identify the defendants by their clothing description. The defendant refused to give his correct identity and provided a false name of Katie Owen, date of birth 6/14/2007. The defendant was later positively identified by a mobile AFIS.
Mr. Bullock, I'm going to find that there's sufficient probable cause to go forward with the case. How old are you, sir?
18.
Don't be a danger to my community, Mr. Bullock. It's just not going to go well for you. I don't know who you have in this life, but if you don't have someone that's willing to pony up to $10,000 to $20,000 for a bond for you, you will be stuck like Chuck in there if you break any of this condition. Do you understand? What are you doing with yourself these days?
So right now we're signing up, ready to go to the military, focus on that, and about to finish school.
You graduate from high school?
No.
You working?
No, not yet.
So what are you doing, man? That's gonna stop right now. As a condition of your bond, you must either have a full-time job or get back into school. And I'm giving you 2 weeks. I'm gonna bring you back. If you've done nothing, it's not gonna go well for you. Do you understand? Days of just in there playing Xbox, smoking, it's not gonna work. Do you understand? Can you reach out to the MAC, please, Victoria?
Okay.
I'm now sending you also for a drug test because I want to know what, if anything. What time of day was this, please?
Judge, I believe this was in the morning time. So most of that.
So it's not in the middle of the night?
Time, rather. I don't know that I have a specific time.
Here's what we're going to do. I'm sending you for a drug test now. You were to come right back. If you fail to test, if you fail to go test, if you fail to come back, I will issue a warrant for your arrest. Do you understand? When you come back, I'll have a lawyer for you. Take a seat, please.
And there you have it. Another intense day in the courtroom where accountability, compassion, and harsh reality collided. We saw a mother pleading for her son who's facing 2 felonies and testing positive for drugs and alcohol. The judge gave him one final chance with an ankle monitor and a stern warning about the law of parties, where just being present at a crime can make you criminally liable for murder. We witnessed sloppy police work derail a DWI case because the officer's report was so incomplete the judge couldn't find probable cause. Another defendant walked free on a gun charge for the same reason. Poor documentation. We heard a powerful lecture about theft convictions and how they brand you unemployable for life. We saw a reckless driving case where the judge allowed the defendant to drive again, but with a zero-tolerance warning. 1 violation and you're done. And we watched a burglary suspect caught red-handed with screwdrivers and gloves, now facing strict bond conditions, including getting a job or going back to school within 2 weeks. The common thread? Actions have consequences, and the courtroom is where those consequences become real. If you found this case as gripping as we did, make sure to hit that like button, drop your thoughts in the comment below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We're bringing you real cases, real justice, and real-life lessons every single week. See you in the next one.